Hey, Jerry,
Hey there.
how are you?
Let me check. I'll get back to you.
Okay, maybe at the end of the meeting you can talk to me about that.
I had to listen to Kent this morning. I'm not sure where I'm at, but
Ken,
That's
can
right.
you give me a quick 2-minute summary on kind of what's going on from your side of the world?
Well, there's been a lot of stuff going on with the banking situation, obviously. Banks have been going out of business literally due to an interest rate environment that we're in. We don't have that issue, being that we're not a depository institution, and we're doing great. But that's been a worry for a lot of people, is the banking situation. So I always tell all these realtors, if you have a listing and you're getting a pre-approval and it's from a bank, call me and get a second opinion.
Yeah.
Because you just never know. Number one, I'm probably going to be priced better than them anyways, but secondarily, there is some uncertainty there. But yeah, it's pretty volatile market right now.
Yeah, so people are looking for an advantage and a cost savings anywhere they can. I'm seeing people kind of force the idea of it being a primary mortgage, and they'll even change residency in order to get a better rate. Obviously, you're going to have your own underwriting guidelines to verify that that's actually happening. But
That's
then,
the number one area of mortgage fraud is residency.
yeah, I think you've told me that before. And then we're also seeing a lot of ARM products that are being taken advantage of. Do you see a big change in the rate that you can get if you go from a 30-year fix to a 5/1 ARM?
No, and I'll tell you why. There's basically is a very large inverted yield curve right now, which causes short-term rates to be the same, or not as good as even long-term rates. So we really haven't seen a big spike in ARMs. There's a little bit of a delta when you're talking about jumbos, when you get into larger loan amounts, over $1 million. There's a little bit of a delta, but it's not that big. No, it's the 30-year fix is still the way
Why
to go.
does that delta exist with jumbo? So in this area, what is jumbo? Anything over 800, something like that?
722,000 is conforming right now.
All right. So why the delta? What is the difference? We like rich
It has
people
to do with
better?
investors just want more money. It's easier. It's easier. I can close a $300,000 loan just as easy as I can close a $1 million loan. And when you're making that interest and it's on a larger product, that's also a higher quality borrower. So it's a less risky product, even though it's more money.
Interesting. I never understood it, but that makes sense because I see that in my business. Quantity is great, but quality is even better. And so if you have
Exactly right.
a good amount of like high-end deals, you can do less deals and still make more money than if you just did a ton of lower end deals.
Correct.
Interesting. I love that. Jerry, in your market, your office is in Bonita, but you also have offices in Naples and Marco. Are you noticing anything from a personal perspective? One of the things I always enjoyed a lot about your guidance was just your perspective over many different years and different markets. What are you seeing? What can you compare this to in your experience?
probably nothing because I haven't experienced this particular type scenario with a pandemic related by, then followed by usurious interest rates and inflation. So I don't think there's too many people that have experienced this before. But I will say this, the desirability to own a home in certain places in the United States is still prevalent in people's minds. And we're fortunate that we happen to be the state that so many people want to come to. And I think last week, we still have a lot of cash buyers versus mortgages. Sorry, Kent, but that's the reality of where we are here. But that too will change at some point in time. The highlight was the Bonita Estera market increase in inventory, 119% increase in number of homes on the market this February versus last February last year. So there are still people, and that's still with diminishment of inventory. Don't forget, there's no inventory available on Fort Myers Beach, Sanibel, Captiva, other close places to the water. And the rental market is still pricey, and Mike had some comments about, the return that you could get in Collier County. We're blessed to be where we are. Now, I'm from New Jersey. My sons are in real estate there. They're moaning, okay? Because they're in that triangular New York, Pennsylvania, New Jersey market. It's all the same. So people still want to be here. That's the plus.
Yeah, yeah, that's good. We've certainly seen a busy spring. I think it was maybe a little late to come into a season, and maybe it'll be early to leave the season, but we've certainly been busy in the spring here, or I guess it's late winter, maybe. Actually just turned spring, right? So we're in spring now. But yeah, we've definitely seen a fury of activity, and there's just no one size fits all. Sometimes you're busy and sometimes you're not. I have a lot of realtors that are just crazy busy, and I have even more that are crickets. And for me, the only thing that I learned from this is you got to own your craft. You got to hone your craft over time. And when we're slow with closings, I busy myself with the other things, mining for clients and putting myself out there. For me personally, I'm always connecting with the different realtor association boards that I'm local to, hiring people. I'm revamping a lobby or revamping our website. We just did a brand new website, for example, where I'm taking people to lunch. That's my time to connect with people. When we're busy, I don't have that kind of time. The only problem, Jerry, maybe you can teach me this, is how do you manage it when the two collide? You've scheduled all these lunches and you've signed up for meetings, and then you start getting busy. That's when it's a little hard to manage.
Best thing I can tell you is never skip a meal.
That's good.
Okay.
Advice. I like that.
And everybody has to go to lunch, have breakfast, have coffee,
Yeah.
whatever the case is.
Right.
That's multitasking. Okay?
It is multitasking. You can build it into your business model. If you like going to lunch, like my dad never liked going to lunch. He eats almonds and a yogurt for lunch, because he's just trying to keep the calorie intake what it needs to be, but nothing extra. But me personally, I never get to go to dinner. I have 4 kids at home. I never get to dinner. I'm eating breakfast in the car. So lunchtime is a great time for me to connect with people, take them to lunch, spoil us a little bit. I love that. Mike, you kind of have that mentality a little bit, don't you?
Well, I can tell you this, getting back to your dad, that candy bowl in the front lobby of your lobby is always half empty.
Right.
That's right. But we
Seems
keep
to
it full.
hover
We'll
around
fill
that
it back
bowl.
up. We'll fill it
And
back
what's
up.
left in it is stale.
So I wanted to take a little detour. So the last couple of weeks when we've done these classes, I've talked about things that I've seen go wrong. As a little teaser, I think it was either a week ago or 2 weeks ago, I talked about kind of meandering between FAR/BAR contracts and NABOR contracts and the little mistakes that I was noticing people make, because something that you don't have to do on NABOR, you do have to do in FAR/BAR. And the example is the condominium rider. So you have a condominium rider in FAR/BAR that you have to include in your contract if you're doing a condo on FAR/BAR. In NABOR, you don't. And the reason why I bring it up is I saw it happen again this morning, where the condominium rider was not included, and it gave the buyer the unilateral right to terminate. It's kind of brutal. That's like a punch in the face if you otherwise had done everything you could to keep that client happy, to keep the deal moving in the right direction. So we spent so much time talking about those kind of issues and the gotcha moments and the examples that we're seeing, that I kind of wanted to dial it back and have a different mindset. And I'm glad that you're on here, Kent. And I'm going to ask Mike this question first, but Kent, I'm going to come to you as this class goes on. But I wanted to talk about trust, TRUST, and not about trust in each other, but the setting up a trust, a family trust, a revocable trust, an irrevocable trust, whatever it may be. these are buzzwords to a lot of people. Mike, what do you know about trusts?
I can
When
spell it.
someone
That's
says, I
about
want
it.
to put it in a trust, I have it in a trust, where does your mind go to?
Honestly, within our family, we have a trust for, my parents set up a trust for each grandchild. But I know very little about it. I mean, when we get to trusts, I'm usually turning to attorneys because that's not our area of expertise.
And that's what
We-
I assume 99.9% of us feel. It's one of those buzzwords that we think we know kind of what it means and we don't. But actually, a funny story. I used to love the buzzword entrepreneurial. I want to be an entrepreneur. I want to own my own business. I want to do all that. I loved that word. And I
Hmm.
remember meeting with my first boss. It was an interview, and she said, "This is a very entrepreneurial job, and very entrepreneurial office." And I'm like, "Oh, that's great! You know, sign me up. I'm in." What she meant was they didn't have any clients. So be careful. Be careful what the buzzword means. So let's talk about trust. Let's talk about that buzzword. Let's try and break the barrier down on it. Dad, what do you think of for trust? So I brought this up as the topic yesterday.
Right.
Your first inclination, the one thing that you said, I need to talk to the client. What do you mean by that?
Because I want to know why they want the trust. I mean, because knowing the why drives whether that's even appropriate, whether I need to get into a big explanation of what it is, and you know, yes, we'll convey your property into this trust, or I want to take time trust. Well, why? Because there might be a more efficient way of achieving the why, or what they're asking for might not even be necessary, and they're spending a bunch of money for something that's not necessary, or it might not work. So you gotta know why they want it.
Yeah, so why do you want the trust? And actually, we get that question. It's a very important question for a lot of things that we do. I'll get a lot of people saying, "Hey, so and so says I need to put my property into an LLC. Can you do that for me?" And the easy answer, I'd probably make more money if I just said, "Yeah, sure. What's it called?"
Right.
But what we always do is we tend to talk our clients out of it in a sense, because we start asking why. Why do you want to put in an LLC? What are you trying to protect against? How do you use the property? Trusts are great for this. So trust. Dad, tell me about it. Is it filed with the state? Is it public record?
No, it's not. It's not. Trusts are a very flexible vehicle. It's Chapter 689 Florida statutes. You know, starting in the 80s, I would have foreign clients would use trusts for both tax reasons and also for anonymity. They did not want Holland to know that they were buying stuff in the United States or Spain or, you know, Belgium. So secrecy was a big thing. You've had people, you know, take title to property in Port Royal because they didn't want the universe to know that it was them owning the real estate. I can go with my parents. They use trusts so that I'm one of 6 children. Certain of my siblings they had concerns about. They didn't want to give them the money right away. They wanted them to be safeguarded against their own issues. So you get people who, you know, a revocable trust is part of your estate planning package, and you use it because somebody might be a recovering addict, or they might marry one miserable person after another, and they're just awful with money, or they're worried about the money ruining their kid's life as they're getting too much too soon at too young an age. Your mother and I mean, we're in the process of revising our trust because when we did it 9 years ago, we were about you and your siblings getting money at too young an age and not working hard. We were concerned that it would turn you into trust fund babies, which I don't like.
See, that's the problem. My whole life, my dad told me I wouldn't get a dime until
Not
I was
getting a damn dime,
35.
I'm spending the last nickel.
So I wasn't going to get a dime until I was 35. Well, I'm 37. I haven't gotten a dime. Like, what are we doing? Something wrong. Okay, so privacy. We don't want everyone knowing our business. There are certain trusts that are set up. Actually, I learned about the Hershey Trust. So the founder of the Hershey Company, when he passed away, put all of his ownership, all of his wealth into a trust. And he specified it for, I think it was like orphan males. It might even have been orphan white males, like really specific, really limited. And that trust continues, and they've had to go to the court to kind of open its boundaries and help, kind of expand the purpose of the trust over the years. It's an interesting story. I think it was like the Vanderbilts might have had a similar trust, and it was for polio. It was, to rid the world of polio. Well, polio has basically been ridded. So all this money that's been set aside now no longer has that purpose.
Oh,
So
there's
private-
trust set up by the Vanderbilts, and we have a Rockefeller we do work for. that
Rockefeller,
We're
they're
set
I
up
think that might have
to,
been the other.
they were set up before estate taxes were passed by Congress. So, they were able to skip all that. So, we have a great granddaughter of the, John D. Rockefeller, and we were actually doing a closing for her. And I'm, oh, goody, her name's Ebuff, I call her. Do I get to see the John D. Rockefeller Trust? No, Don, they're not going to let you see. So
No.
damn, I'd love to see that.
All right, so privacy is a big one. Protection against others, against yourself. If you've got people that are, I always bring up one of the items is if you had a child who was handicapped and couldn't take care of themselves, or maybe they were under the care of the state. And so I have clients that they would put money in trust in the event the state wasn't taking care of them. But
Right.
in the event the state still was, well, we didn't want that money in their name. We wanted it to be separate. So they're a beneficiary only if the state were to stop taking care of them. So that sort of thing might apply. The other thing that I usually tell people, and you're probably getting the vibe here, is if you are wealthy, trusts are a really great tool for distributing wealth over a longer period of time. It's not exactly this simple, but a will is kind of like a one-time payment for most of the cases. Whereas a trust, you can more rule from the grave. You could kind of set it up like, the money shall be held aside until, they have expenses for school or housing or whatever it might be. And there might even be provisions to stop money from going out in certain circumstances. Whereas a will, it's kind of like upon my death, half of it goes to you and the other half goes to Red Cross. You could do it.
Actually, what we have right now, Christian, is it's called a pour over will, that if your mother and I got in a car crash, everything goes to the trust. So, the beneficiary of our wills at this given moment is the trust for you and your three siblings. And then it's distributed according to the terms. Christian gets 0, the other 3 get everything. Just kidding.
So that was the three-headed monster when I was practicing law in Atlanta. Now, for context, in Atlanta, almost every one of my clients, this was their principal residence. This was most of the time their only home. And so when someone would say, hey, I found out online that I should put all this into a trust, I'd ask them these 3 questions. Is there a reason why you want to be private? Are you in a rock band? Are you a doctor? Do you get sued a lot? Are you famous? And they'd say, no, none of that. And I said, well, is there anyone you need to protect? Do you have, a sibling that you don't trust? Do you have a handicapped child? And they said, no, nothing like that. And then, are you exponentially more wealthy than all the rest of us? And I said, no, nothing like that. I said, okay, well, trusts are expensive. Trusts are a pain. You have, once you hire the lawyer to do a trust, you kind of have to hire a lawyer to do anything else with the trust. So for most of those people, I never really recommended. I didn't push on it. But upon coming back to Florida and running Ross Title and Ross Law, I would add a 4th number to this list. And that is probate. So everyone thinks that probate is the 4-letter word, and in a sense it can be. In my experience, probate, well, I'll give you the summary, the elevator pitch on probate. Probate is the court that is authorized to determine where your money goes after you pass away, or who to trust with distributing your estate. So every county in the state, in the country, as far as I know, has a probate court and you're going to submit the will, and you're going to petition the court to say that this is the right will. This is the person who's going to be appointed to distribute it. And it could be a personal representative or executor or administrator, any of those words. And in most people's experience, probate's a huge pain in the neck. What a bummer, right? That's dad's property. It should now be our property. Like, why do we have to spend 3, 4, 5 months in court waiting for the judge to sign off on it? Well, there's a lot of reasons why. And personally, if you're inheriting property, probate's not the worst thing in the world. You know, at least in this area, most uncontested probate matters are, you know, $3,000, $4,000, $5,000 to an attorney. They handle it entirely. A couple months later, the judge signs off on it. Like, it's not that big of a deal. But if you've got some of these other items, or if you are out of state, if you have a home in New Jersey and a home in Florida, you're going to want to avoid probate in both states. That sounds like kind of a pain. So there are a lot of our clients that have that scenario. They own a condo in Florida, they own a house in Florida, and they want to avoid having to probate in both states. So for them, probate makes a lot of sense. And then also, what if you're out of the country? If you're Canadian, probate's probably not something you're going to want to do. You're going to want to keep it in trust, talk to your CPA, talk to an accountant, a tax attorney, and kind of set it up to avoid those types of issues. Therefore, we do see a lot of buyers holding property in trust. Now, it's not filed in a court anywhere, typically. And what I'm going to do is I'm going to show you what a typical trust agreement looks like. Now, I've changed the names to kind of hide any sort of information that could have been there, and just put it to
protect the innocent.
And protect the innocent. So this is just a trust. This is not filed anywhere. It's just a piece of paper that you keep in your desk drawer, kind of like a will. A will is not filed anywhere until probate. But saying, hey, we're setting up a trust, and here are the trustees. It's going to be Don Ross and Christian Ross as trustees for the beneficiaries. And the beneficiaries could be anybody. It could be the two of us. It could be the kids. It could be grandkids. It could be the neighbor. It could be Red Cross. It could be anything. And these things can be pretty extensive. They talk about taxes. They're going to talk about, if the spouse dies, if one spouse dies before the other spouse, what if there's no longer any need for, for things to be set up in trust? When can the trust be dissolved? What if they move to a different state? What if they move out of the country? Like, all these what ifs. And so they can get pretty complicated. And you don't need to see this. You don't need to read it. Just trying to give you perspective, give you a little context as to what these things look like. The key on this is that at the very end, you saw how many pages this was. It is signed and witnessed and notarized. That is really key. We want to make sure it's valid in the state that it was executed in. So I would say that you're going to want to make sure these things are signed, witnessed, and notarized. But you can see here, this is your table of contents. Transferred property during grantor's joint lives upon the first deceased spouse, the first deceased spouse property, holding trust, presumption of survivorship, takers of last resort. There's a lot of thing going on here. If the beneficiary is underage, if they're a minor, what do we do then? That sort of stuff. So spendthrift provision. What is that, Dad? What is that keyword there?
If somebody's blowing their money, using you and your siblings as an example, we right at this moment, and we're getting rid of the trusts, actually, because you guys are old enough, since you're way old now. But if you have one of them wanting to go out and buy a Maserati and just blow their money, a wild weekend in Vegas, you can limit that. There's language in like my parents' trust on if somebody has a drinking problem or something like that, I had the discretion to withhold payment. They're all designed to the particular needs of the family, and it requires you to be brutally honest about the pros and cons of your children, their weaknesses, protect them from themselves, and But spendthrift, it's for people who are crazy.
Yeah, or someone that might have been sued and they were, you know, there's going to be a distribution unless that distribution could get taken by a creditor or
Yeah.
something like that. You can
A lot
have
of
that.
trusts that I get, Christian, are from other states. And we have, again, the Florida statute where 689.071, if you put the trustee's powers on the deed and you cite the statute, nobody has to look at the trust. So you can have people who are moving down from New York or Illinois and they're putting it in their Illinois trust. You know, you just want to make sure the right powers are on the deed. And the Canadians you refer to, they have cross-border trusts where you have some Canadian lawyer who drafts the trust and the Canadian lawyer is the trustee. And then the beneficiaries typically are the kids of the person buying the property down here. So, you know, they look at tax treaties, they look at the pros and cons of how old their kids are, how old they are, you know, family issues.
Well, it's good transition, talking about the statute. So this is where I want to draw it back to buying and selling real estate and how we need to look at trusts in our world to make sure that we're well educated about the facts of the trust and how it works. So, and Kent, this is where I'm going to drag you into it as well. First, if you're the listing agent, or if you're trying to make an offer on a property and you download the deed on the Collier County website or the Lee County website, you get the deed and it says that it's held in trust. Now, it's going to say the trustee's name as trustee. So it'll be John Smith as trustee of the Smith Family Trust. Now that's a requirement because the trust is not an actual entity. It's just like an agreement. So the only thing that you can do is that you actually have to hold title as trustee. So they put the title in the name of the trustee who holds it for the benefit of the beneficiaries of that trust. So you're always going to see that. You're going to see John Smith as trustee. So the first question, who do I have sign? And so, Dad, to your point, the deed itself usually has trust powers.
Right.
Trust powers mean that basically the realtors and the lawyers, we don't have to see the contents of the trust. We don't have to read that 100-page document.
We don't want to see it. It
We
might
don't
be a
want to see
Virginia
it.
trust.
It can make it harder. We want to see on the deed that it says, you know, they have trust powers to sell, convey, refinance
Right.
without any additional authority required. So
This
that's
is
really
always
cool.
homestead. There's always
Yeah, so
homestead
if we're
too.
for homestead, yeah. So in that scenario, when you look at the deed, that's usually who you're going to have sign is the trustees that are listed. It could be one trustee, it could be 5, it could be 100. You're going to look at those trustees and you're going to verify, does it say on there, does it have those trust powers? And Dad, you said statute 689, right?
689.071. It's usually cited right in the deed.
It'll
and
be
it's
cited
based on
in the
language.
deed. And if you
Yeah.
have questions about finding it, if you're unsure, that's when you call us. That's when you ask, because we're just talking about those buzzwords.
And if the people are living there, get the spouse to sign, because if it's homestead, you know, you still need that other person.
Yeah, so homestead laws overcome the trust because you can't kind of kick your spouse out of the way and say, you know, they don't need to sign. They're not one of the owners. Homestead makes them an interested party. So have everyone sign that you can. We've written a lot of articles about this topic, and be safe. You know, when in doubt, just have everybody sign. Now, how they sign is an interesting one. So a lot of times there's not enough room in the signature line to put the whole thing. So what I would usually recommend is that on page 1, you're going to specify, you know, John Smith as trustee of the Smith Family Trust. There's usually enough room in both the FAR bar and NABOR contracts to put that whole thing right on page 1. And then on the signature pages, which is, you know, at the end of the document, you just have them sign John Smith as trustee. That's the key. Some people will make the mistake and they'll sign the Smith Family Trust. That's not accurate because the trust can't sign. It would be the trustees that sign. So if there are 2 trustees, if it's Kent and Christian, it'll be Christian Ross as trustee, and it'll be Kent Williams as trustee.
I also get them to sign individually because the underwriter, the title insurance underwriter wants that.
Yeah, so, well, and that's not going to hurt anybody. at closing, we're gonna make them do that. At the contract signing, maybe it's not as relevant. It might be okay without it, but again, if it when in doubt, have them sign everything. So then the next step would be, well, what if one of the trustees has passed away? So Dad, what would you do in that scenario? You've got, John and Jane Smith as trustees of the Smith Family Trust. It's listed right on the deed. There are trust powers. John passes away. Can I have Jane sign?
And 99% of the time, the underwriter requires that we record an excerpt from the trust showing the successor trustee in this given situation, and that the trust is still in full force and effect. So we take that particular page showing who the successor trustee is and have a blanket affidavit that says the trust is still in full force and effect. And here's the successor trustee, on page 14 of the trust agreement.
Well, the real answer though,
at the time.
because we're talking about at the contract, right? So when you're signing a listing agreement and Jane's the only one there, obviously have her sign it, but that's when you reach out to your attorney, talk to my company, Dad, reach out to you and say, hey, Jane's passed away or John has passed away. What do I do? And we're going to ask for a copy of the trust. We're going to want to see it because we need to verify, okay, if John passes away, is it Jane exclusively? If so, we're golden and we can just have Jane sign. Or it might say that, upon John's passing, Jane and then the daughter is the successor trustee. So it could be that. So as you saw in this document, it's 100 pages. It could say that we need a death certificate and we need an autopsy and we need, and if he died from alcohol poisoning, then it needs to be, Jane alone. And if he didn't die from alcohol poisoning, then, my cell phone can be trustee, right? That's an exaggeration, but it could say literally anything as to who the next trustee would be. And so we have to look at it. And that would be the question. You'd say, you'd pull your listing agreement. And before you head down there, you're going to look at the deed and it's going to have Jane and John. And when you show up and John's not there, you're going to have to ask about him. Where's John? Where'd he go? And they're going to say, well, John passed away a couple of months ago and that's why we're selling. So I'm so sorry to hear about that. Do you have a copy of the trust? Because I noticed that you own this property in the trust. 9 times out of the 10, the client doesn't even remember that it's held in trust. They totally forgot. I forgot that we did that.
My lawyer did it.
Yeah, the lawyer did that. I didn't even remember. I don't have copies of it. That's when you do your due diligence. That's when you say, well, we're going to need it. Let's get on a conference call with Don and Christian. Let's see what they'll need. And, that's part of the service that we provide, is that we don't want to wait until you get to a closing to deal with these issues. Let's deal with it when you sign the listing agreement. Now, Dad,
I get these things beforehand from clients, from realtors, and they want to make sure that there's not going to be a problem when, they sell the property and, title insurance is ordered. So we'll run it by some of the attorneys at one of our underwriters and say, if we do this closing, is this going to be okay? Will this satisfy?
And I think that's a huge value to all of us, which is, we want to make sure that your closing is smooth, but your entire experience is smooth. The client tends to remember, the most stressful moment and the last moment that they had with you. That's what's going to jog their memory. You just don't want them to be the same thing. You don't want to be stressed at closing.
It was probably a $10 million transaction and the lady's selling it for like the 14th time. And I said, just get us the documents and I'll run it by so-and-so at, say, Old Republic. And can Old Republic, authorize title insurance under these circumstances, this probate document, this order from the circuit court judge, is this enough? And we get pre-approval of the commitment that we anticipate doing in the future.
Well, and then it has a little bit more power when the listing agent says, hey, Ross Title already ran title on this and has authorization to issue clear title. That can be pretty helpful when, wanting a smooth closing.
Sure.
I'm sharing another thing that, Dad, that you referenced, which was a certificate, basically a summary of the trust. And this is something that we will typically require if one of the trustees has passed away or there's some sort of successor trustee in place. Another example, the trustee may not have passed away. Maybe they're just not capable of signing or administering the trust, or they've resigned. We would need to file this with the deed to show that the people we had signed did have the authority to do so. And it's usually 1 or 2-page agreement. And it's just a summary of, here's the name of the trust, here are the trustees, here, this is who has the authority to sign. And so we will record that of record.
One thing that comes up a lot, Chris, is people trying to use powers of attorney to act on behalf of a trustee. And the short answer is you can't do that, unless the trust says so. And if I point you as my trustee, I don't necessarily want you to point somebody else to act on your behalf that I don't know. So,
all right, so here's the last point, Dad. We're making an offer. It's Sunday night. We're finalizing the contract, and your client says, "Oh, I want to own this in my trust. Should I call my lawyer first? Should we wait till tomorrow to get the name and to figure out if that's possible? Should we wait?" And you've spent a whole day drafting this, and you're worried that the seller's going to go with someone else. What would you recommend?
I'd say no. If this is before the closing, Christian?
I'll prompt you on this one. The reason I would say no, and I agree with you, Dad, the reason I'd say don't wait is that these contracts are assignable.
Right.
So put it in your name personally. Sorry, I didn't mean to throw you off based on that.
No,
So put it in your name. We'll deal with the trust information later. The NABOR contract is assignable all the way up. I think it's 15 days before closing. Historically in this area, other attorneys and sellers have allowed you to assign the contract.
Yeah,
right up
they
until
don't care.
closing.
They just need enough time so they get their sellers to sign a proper deed. If there's
Exactly.
another case.
And then FAR/BAR, it's check the box. So you check the box that it's assignable, and then you've protected your client. You say, here it is assignable. Let's get it out. Let's not waste any time. You could always do an amendment. You could do all, the important thing is that you get the offer in. I don't think, if the client says I need it in my trust and yada, 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 I wouldn't let that stop you from making your offer.
Yeah, I always think of the realtor on a Saturday or a Sunday, and they have the buyer who's just anxious and they love it. But it's an expensive property, and I'm not sure how to take title. Well, they point to, page 3 of the NABOR contract. Look, you can assign it, or paragraph 7 of FAR/BAR. Look, you can assign it if they check the right block. It doesn't matter. You can sign it in your own personal name and talk to your lawyer on Monday. So
Right,
you want to get
exactly.
the deal accepted on the weekend.
Perfect. Now, I've got 2 other things I want to point to. Ken, you're going to be on number 2. I want to know what trust, how you see it as a lender, and if you can actually close in the name of a trust. But first, cost. This is not free. Setting up a trust costs money. Going through your estate attorney and figuring out your estate planning can be an expensive process. I'd say on the low end, you're probably $3,000, $4,000, $5,000 to set up trust, will, power of attorney, healthcare directive. That's on the low end. You could spend hundreds of thousands of dollars on estate planning, given a very complex estate. So in that scenario, that goes back to my point of wealth. If you are very wealthy, it's a good use of the money. If you are not, I would focus on other things. I would put money towards, paying down the interest rate on the mortgage. So to that point, Kent, mortgages. How does the lender evaluate a trust? Can a buyer get a mortgage in the name of the trust?
Yes, for us, it's the only issue is liability, right? We have to be able to foreclose on somebody if they don't make their mortgage payment. The trust is
Gosh,
fine.
that's brutal, Kent. Goodness gracious.
It is what it is, man. I get, it's all about risk in our business, but yes, a revocable living trust is acceptable. But we definitely going to have a guarantor or somebody that's signing that's going to be on the hook.
Yeah, so I've done a lot of closings where the buyer takes title in the name of the trust and signs the mortgage in the name of the trust, and then it'll be individually and as trustee. It's not it's an option. Doesn't mean you can't do it. It's totally on board. The only downside is that the lender, it's like one more thing that you have to add to the underwriting that can be confusing to some clients. So what I tend to suggest is if the borrower doesn't have everything together, or if the lender's kind of making them jump through so many hoops, just do a deed after closing into the trust. It doesn't violate the note or the mortgage. Just do it later. Don't even worry about it.
You're just gonna pay additional stamps but yes, that's exactly right.
Sometimes. Mike, what are your thoughts? You just listened to that whole thing and you were just enamored with it.
Way too much information.
It's a lot of information. So,
I know you're down the hallway, and if a trust pops up, I'll walk down the hallway.
well, I think that's the big point here. You're issue spotting. And the key for you is, how do I sign the contract and the listing agreement? What do I need to look at the deed, and I can't be freaked out if it says trust. I know Christian said something about it. Let me just call him to double check. That's really important. Hey, I can't fit it in the line. What should I do? What did Christian say? Oh, put it on page 1 and then have him sign as trustee. It's these little things that matter for realtors and for the day-to-day. Don't overthink it, but just have a solution, have your procedure. Jerry, you were always really good about that. Is there anything else that you could kind of plug in for us after kind of hearing this class?
The way the market is, get it signed, and then if you need to make a change, do it later.
Yes.
There you go.
Otherwise, you don't have anything to do. If
You don't have
get it
anything to
signed.
do.
You get it-
Priorities. Don't let that be your stop.
Right,
Let it funnel down further. Get in touch with, before you put down money even. You could sign it on a Sunday and call me on Monday morning. In the meantime, get the contract signed so that I have something to work off of.
They got a saying, don't let perfection stand in the way of good enough.
Yeah,
That's
Dad,
something.
actually, you and I talked about this over the weekend. I referenced something that Ted Kennedy had said about healthcare. And he said his number one
good one.
regret, or maybe not his number one regret,
Chappaquiddick.
but one of his major regrets politically was that he didn't just get some sort of health policy, health insurance, national health insurance passed. He always let perfection stand in the way of getting it passed. And if he were to do it over again, he would have tried to ram it through and then fixed it later. I don't know if that's working or not, but I just thought that was a really neat way to think about it. And you have to do it with some of the information. You have to know enough. You can't be kind of just making it up, because there's some things we can't protect you on later. But as far as trust, if you overdo it, you'll be okay. You can always assign it as a buyer later. So that's the key. Thank you, guys. Another good class. I like that one.
Thank you, Christian.
All right,
Thank
good luck,
you.
everybody. Call if you need us.
Take care.